Good evening and welcome to Arizona Horizon. I'm Ted Simons. Former President Donald Trump today was found guilty on all 34 charges of falsifying business records tied to a hush money payment to a porn actress before the 2016 election. The 12-person jury came back with their verdict at the end of the second day of deliberations. Donald Trump is now a convicted felon. He's the only former U.S. president to be convicted of felony criminal charges. Trump was released after the verdict. There was no bail involved. A sentencing date has been set for the morning of July 11th, 4 days before the start of the Republican National Convention. After the verdict today, Trump called himself a, quote, very innocent man, and the proceedings a, quote, rigged trial and a disgrace. Joining us now to discuss this historic verdict is Roy Herrera, former Assistant U.S. Attorney General and former Assistant Attorney, I should say, and founding partner of Herrera Arellano Law Firm. And also joining us is Mark Ikonovich, former U.S. Assistant Attorney, not General, from the law firm Ballard and Spahr. All right, gentlemen, good to have you here. It's been a very busy day, and thank you both for coming in because we're looking for the legal insights and the legal aspects of all this. First of all, Roy, we'll start with you. Guilty, all 34, no split verdict here. It's a slam dunk. Were you surprised?
Not really. And I think it's important to just note that the criminal justice system worked the way it should, right? I mean, we have the prosecution who has to prove beyond a reasonable doubt that the defendant is guilty. The defendant had an opportunity to defend himself. That's what Donald Trump had the opportunity to do. And obviously the jury agreed with the prosecution that he committed these crimes. Am I surprised? Not really. I mean, I think, and we'll probably get into the specifics of, the defense strategy here versus the prosecution strategy here, but I think that there were some flaws in what the defense tried to do here. And again, it didn't surprise me. I thought the testimony from some of the witnesses, like Michael Cohen, was pretty good for the prosecution. So as a result, this wasn't really a surprising outcome.
But again, Mark, we got 12 jurors here. You got 34 counts. It was, I thought, a relatively complicated case, although the prosecution kind of narrowed things down here. Not a split verdict, not one person wavering. I was surprised. Were you surprised?
It's a resounding verdict. I don't know if I'm surprised because I think the evidence was very strong. There was a lot of good testimony, like Roy said. It was corroborated with documents and phone calls and photographs. The defense strategy, as Roy alluded to as well, was questionable, and I think some of that had to do with the defendant, arguing that, the relationship with Stormy Daniels never happened. Probably not the strategy to take when you're trying to establish your credibility. Why are you paying someone $130,000 if nothing happened? Those are hard things to sell to a jury, and juries, in my experience, are relatively wise, and we have a special, system of justice in this country, and in this case, I think it worked relatively well and relatively quickly.
And again, Roy, what happened here was he was found, all these counts, falsifying business records, having his extramarital affair, his fling, whatever it was over there. That's not what he was charged with. He was charged with it's always the cover-up, isn't it?
Well, it is, and this is a somewhat novel legal theory by the prosecution. It's a falsification of business records charge, which is normally in New York State a misdemeanor, and it became a felony because it was done in conjunction with or in support of another crime, the other crime being a violation of our campaign finance laws, because remember, this is all related to, paying these hush money payments so the story would go away in the eve of the 2016 presidential election. That's what made this a felony. That's why he is now, a convicted felon and facing, really, I think, up to 4 years in prison because of this guilty verdict.
Well, and again, as far as that is concerned, the timing of it, I think it was noted by the prosecution that the affair happened in like 2006 or something along those lines, but the money payment wasn't made until the eve of the election. You can't make it any more clear than that, can you?
It's pretty damning. I totally agree with you, Ted. The evidence was very strong, and the fact that you get jurors that both parties were able to have input into who the jury was going to be.
Yeah.
They were juries of their peers, and you had a judge overseeing this, instructing the jury, and they came to a quick conclusion on all 34 counts.
As far as the jury wanting to rehear the judge's instructions, what did you make of that?
That's relatively common. In a lot of jurisdictions, the jury is able to get a copy of the jury instructions. In New York, it's my understanding that that's not the case, and they just had to pay very close attention, and those are very complicated instructions. As a lawyer, it's difficult sometimes to parse exactly what the elements of the offense are, but that's what those are for, and they were taking their job seriously, and I think most juries do.
And the other note the jury wanted, Roy, was basically they wanted to rehear the testimony of Michael Cohen and the publisher, the former publisher of the National Enquirer. What did that tell you?
Well, I think, again, it kind of goes back to your question about whether I was surprised or not. I mean, the fact that they wanted to hear back the testimony of Michael Cohen, despite the defense's efforts to make Michael Cohen seem untrustworthy, he did hold up on cross-examination pretty well, at least from what I saw, and he was a credible witness from what I saw. And clearly, I think the jury believed that. But the moment they asked for that testimony, along with the fact that we got a verdict within 2 days of the closing of trial, really signaled to me the moment that I knew that the jury was coming back with the verdict that it was going to be guilty.
And Trump's defense, obviously, he did not take that. Did you think that was wise for him not to take the stand?
I think it would have been disastrous
Really?
for Donald Trump to take the stand. Yes, I think most lawyers counsel their clients not to take the stand. Donald Trump in particular would have been a horrible witness. Horrible.
Yeah, but what does that mean now? That means what? They would have taken 1 day instead of 2 days? I mean, he's convicted on all counts.
That's true. That's true. It can't get worse than
Couldn't
this.
get any worse than that.
But I think it can get worse in terms of sentencing. If a defendant takes the stand and lies while they're on the stand, that's itself a crime, committing perjury, and that's a risk for him.
That all or nothing defense on Michael Cohen, though, I mean, it sounds, as we referred to, it sounds like the jury believed what they heard from Michael Cohen. Was there no plan B with the defense?
It didn't seem that way. I mean, obviously, they had a very aggressive cross-examination of Michael Cohen as well as Stormy Daniels. Both of them, again, held up relatively well. You know, they tried to get Michael Cohen to sort of show that he had some sort of reason to lie here about what occurred. That obviously didn't happen. The same thing with Stormy Daniels. They tried to, get into her past and, sort of make her seem like she wasn't trustworthy because of her prior profession, things like that. And both of the witnesses held up pretty well, which I think, once that happened, put Donald Trump in a pretty bad position. I also will say, and I totally agree with my friend Mark here, which is that their emphasis on the idea that the actual affair didn't occur, I think was a real mistake, because I think it was pretty clear from the testimony, from the evidence, that it did occur. And the real question was there a campaign finance violation here or not? That's really what they should have focused on.
Was the defense focused on an appeal? I mean, did they know they were kind of sunk here, and were they working toward the future?
I don't know. It can be difficult as a defense attorney to get outside of your bubble. And especially with a client like that, it can be very difficult to manage your client. And I think you saw that in the reporting that, the client was falling asleep at counsel table. And, a lot of the strategies that they took, it looked like they were playing not to the jury, but to their client. And that's always a losing strategy.
That business of falling asleep, that business of attacking the judge. Again, we had Paul Charlton, former U.S. attorney here, and he was saying the juries, they like the judge. They trust the judge. They don't like it when people make fun of the judge or are abusive toward the judge. Was that a factor?
It's, the jury's not supposed to be able to see what's happening outside the courtroom in terms of the news reporting, but that antipathy and the mistakes made by the defense in terms of what was said during closing arguments regarding the not sending a man to prison based on Michael Cohen's testimony. And I totally agree with what Roy said too about Michael Cohen holding up relatively well. Going after the lawyer that your client chose to be his lawyer as a scumbag is also a very difficult argument, because as prosecutors always say when there's a conspiracy like this, that we didn't choose that person. The person that chose that, and that they put it especially well in this case, we didn't go to the witness store to choose Michael Cohen. Donald Trump chose Michael Cohen because he knew Michael Cohen was a scumbag and was not going to tell the truth. Yeah, interesting. All right, sentencing July 11th. Are they going to move that day? 4 days before the Republican National Convention. Could that be moved?
I don't think it will, because it seems like all the parties were comfortable with that date. The real question again is, in a normal world, if he gets prison time, would he be, remanded to prison immediately? Obviously, I don't think that's going to happen in this case, because he's got to go to the the Republican National Convention, he's got to run a presidential campaign. So if there is prison time, and he doesn't have to get prison time, mind you, he could also get probation. But if there is prison time, it's likely to start at some later date, and that's all going to get worked out.
Who decides the sentencing? Jury, judge? Who decides?
The judge.
The judge. So it is the judge.
Mm-hmm.
All right. Again, factors like contempt. I mean, the judge did know what Donald Trump said. The judge was aware of his behavior when the jury was out of there. Does that factor into sentencing?
I think it does, and I think it rightly does. What you consider at sentencing, or what judges are supposed to consider at sentencing, are both the factors that were involved in the crime that was the crime of conviction, in this case 34 counts, and the other factors are the individual factors of the defendant and whether this defendant poses a likelihood of reoffending. And this judge gave very stern warnings to the defendant, in this case, former president, to not say things out of school and not say things out of court about the witnesses and about the judge and about the judge's family. In this case, Donald Trump was attacking not just the judge, but the judge's daughter. That doesn't play well, and that doesn't show sort of someone who's learned their lesson about having their first experience in the criminal justice system.
And yet, a first-time nonviolent criminal. Does that play? Again, no remorse, no regret, but first-time nonviolent. What do you think? Is he going to get prison time?
So that's another factor here, as Mark mentioned in the sentencing, is obviously prior criminal history, of which Donald Trump has no prior criminal history. I think the judge has gone out of his way in appearing to be fair. I think he understands the larger implications of the case, at least that's what it looks like. And in things like, for example, like the gag order, that very clearly Donald Trump has violated multiple times during the trial. In a normal case, the defendant would be probably thrown into jail for those violations. The judge didn't do that. And I think it's largely because I think he's trying to appear as much as possible, given the public nature of this case, to be fair.
Yes.
And so I don't think that even the things about being combative with the judge and other things like that are going to play a real factor here. The judge is going to make sure that at least they don't appear to be a major factor here or any factor here. As he does the sentencing, I think he's going to stick to what he has to under the sentencing rules.
Is that gag order still in place?
I believe so, through sentencing, I would
Through
believe.
sentencing. Okay, well, good luck with that. Last question. We got to get out of here. And Mark, we'll let you take this one. Do people understand how historic this day is? This is a former United States president criminally convicted.
Yeah, it is remarkable. It takes my breath away in a lot of ways that we're sitting here and he's the anticipated nominee for the Republican Party. He's now a convicted felon, and he's awaiting sentencing on these very lurid charges, as you outlined, relating to fundamental issues of character. And as the prosecution pointed out in their closing, this isn't just a matter of a white-collar, run-of-the-mill offense, but this is an offense that possibly helped him get the presidency by keeping this very lurid story out of the news at the time. And what a different world we would be in had Donald Trump not won in 2016.
Legal Minds, Mark Ikonovich and Roy Herrera, good discussion. Good to have you both here. Thank you so much for joining us.
Thank you.
Thank you.